This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. If you have an immigration problem, please contact me as soon as possible and I'll do my best to help you. Some further good news, which is a joy to report, as the Home Office relaxes its rules on applications for leave to remain. In this video, I'm going to be discussing in particular how the Home Office offers extensions to people denied settlement and go into it into a little bit more detail. As mentioned, this video will be covering the positive news issued after the Home Office changed its guidance in respect of pending settlement applications, that's ILR applications. The guidance covers the aspect where officials should vary an application themselves for ILR if they consider the person doesn't meet it, and instead grant an extension of permission to stay, which is also referred to limited leave to remain. That the published reasoning behind this was to ensure that people that apply for settlement and who do not qualify for indefinite leave to remain, but do qualify for limited leave to remain, are not left without immigration status and are not required to make a new application or appeal or are subject to the hostile environment. So it's welcome news, it's pragmatic and sensible. In short, and for the reasons set out below, this ought to mean that if you apply for settlement, but for some reason or other you don't meet it, you will automatically be considered for limited leave to remain rather than simply being refused, i.e. if you don't have the Life in the UK test, for example. This is very welcome news as it will or could save people a huge amount of time, money, stress, and being subject for an unnecessary period of time to the hostile environment. Now, this new guidance relates to settlement applications made under the following categories: settlement family life, settlement private life, the innovator visa, most importantly Appendix FM family life, and lastly, and probably not that most important, Appendix Hong Kong British National Overseas applications. So therefore, when someone applies for settlement in one of these categories, which I've mentioned above, but falls foul of meeting a requirement, say the English language or the Life in UK test is absent, the decision maker has got to follow a new process rather than just refusing it. First of all, they've got to consider the settlement application to decide whether or not to grant indefinite leave to remain. If the applicant doesn't meet the requirements of settlement, before refusing the settlement application, the caseworker must consider whether they meet all the suitability and eligibility requirements to be granted further permission for leave to remain on the current route. If the caseworker believes that the person is likely to meet the suitability and eligibility requirements, they must record on the casework system that they intend to vary the application for an application for settlement to one for permission to stay, subject to payment of the immigration health surcharge. And that usually forms a letter that goes out. So once the immigration health surcharge has been paid, and if the applicant has already been found to meet the eligibility and suitability requirements, the caseworker should then go on to grant limited leave to remain. If the immigration health service has not been paid, or where relevant, a fee waiver has not been applied for, the caseworker must reject the application. Where an application is rejected after this process, the settlement fee is not refunded as the applicant has had a full consideration of the settlement application. Now, so that's a disadvantage. The advantage of this process is that it is much more simplified getting people to vary their own applications, which would include paying another application fee, filling out another form, uploading further supporting documents, and at the same time seeking a refund of the previous application fee. However, with the benefits which come with this process, which is the Home Office automatically varying an application, there is one tricky issue, and that is how to challenge these decisions. The guidance says that if a caseworker considers the application for limited leave to remain are met instead of indefinite leave to remain, they should write to the applicant, inform them about the decision, and then give them a period of 14 days to pay the immigration health surcharge. A formal refusal letter is not issued, but the letter informing the person that they need to pay the immigration health surcharge is a conclusion that they are not going to get settlement. As I mentioned earlier, In a case where the immigration health surcharge is not paid, the caseworker comes under the obligation to refuse the application as invalid. The concerning part here is that there is no right of appeal or administrative review where you have an invalid application. However, there is provision for the caseworker to consider further information provided by the applicant if they believe there has been an error in the decision that they do not appear to qualify for the settlement. It is therefore vital for me to highlight that caseworkers are instructed to only consider the information where it is relevant to the reasons they do not meet the settlement application. By not refusing the application outright, the Home Office does not trigger refusal which would generate a human rights claim, and therefore there is no appeal to the tribunal. So you don't get ILR, you get limited leave to remain, but you do not get an appeal. The only, therefore, remedy that is open is judicial review. It does not seem possible for the applicant to ask the Home Office to refuse the application and allow them to challenge it by appeal instead of rejecting it as invalid. This is something that the courts have decided. So therefore, it is important that if your application for settlement is varied by the Home Office because they say you don't meet the settlement requirements, and then they give you a 14-day letter to pay the immigration health surcharge, it's worth paying because you will be granted limited leave to remain, as opposed to having your application treated as invalid and losing the money for settlement and becoming an overstayer. This is because treating an application as invalid will effectively end any Section 3C leave, and as a further result will put someone subject to the hostile environment. So it's good news that the Home Office have taken a pragmatic step that, so if somebody applies for indefinite leave to remain and they don't meet indefinite leave to remain because, say, they've forgotten to put the English language test in, or that they haven't passed the Life in the UK test, or they can't pass it, but they meet all the other requirements, that the Home Office will vary the application and will grant them limited leave to remain. If it appears later that there's been some error, then yes, it can be challenged. But what it does mean is that the people won't be refused with or without a right of appeal, and won't be forced into the hostile environment, won't be forced to make a new application, won't be forced to go through the whole rigmarole of starting again. So some welcome pragmatic news which ought to save a lot of time and ought to save a lot of money. It's pleasant to report some positive news from the Home Office and that some sense seems to have prevailed. I hope more comes in the future. Thank you very much for watching. Do stay safe. Please subscribe to my channel. And again, if you have an immigration problem, please contact me. This is Paul Turner, the Immigration Barrister at Imperium Chambers.